Meeting of the House Judiciary Committee. We've got several items on the agenda today. I'm going to take Representative Caldwell bill up, which is House Bill 323 Code Revision bill. He's in another meeting. I figured, and Wayne is with us, Wayne Allen from Legislative Council. And to the new members, and those in the audience are not familiar, we have every year a bill that we call the Code Revision Bill. And what that means really is there are several things that are discovered throughout the year that address either misspellings, punctuation errors, misnumbering of paragraphs perhaps. And so what we try to do is get that resolved through one bill as opposed to separate bills, of course, covering multitudes of these code sections. The bill is set up based upon a section for each of the titles of the bill. And we have before you House Bill 323. I will be happy to present in the absence of Mr. Caldwell. One thing we're doing is the first section is going to be removed. We felt from some language there we wanted to not get into having the changes that they're seeking there as far as the language, but everything else in the bill does remain the same. And so if you want to thumb through it and you have any questions, I say the basis of it is really just to do corrections of either punctuation, spelling, capitalization, those type things. And if there's no questions, anyone have a question they wish to ask regarding House Bill 323? If there are no questions, the chair will entertain a motion.
Do pass.
We're going to do a do pass as amending the bill. Let me say I'll move to amend by striking out section 1 and renumbering the, actually it won't be a need, just be section 1 will be a blank reserved, correct? So we'll change section 1 to show still section 1, take out all the language, and just place in there on line 11 reserved. With that amendment, I propose that amendment.
Second.
We have a second on the amendment. All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. That amendment carries. Do we have any further amendments? There being none, the chair will call the main question, which is a due pass to House Bill 323 as amended and as a committee substitute, LC 336680. All in favor, please signify by saying aye. Aye. Opposed, like sign. That motion carries. Thank you. Thank you too, Mr. Allen. We next will have Mr. Illustration here. I forgot if he had something pending too. Mr. Werkheiser, is he? There you are, Mr. Werkheiser. We got your bill out of subcommittee, and we'll let you now present it in full committee. This is House Bill 319. We're working off LC 288265. Glad to have you with us, sir.
Yes, thank you, and I appreciate you covering for me yesterday. I'll keep this pretty brief. It is a one-word change. It changes the limit from $10,000 to $30,000. It raises the maximum amount of reimbursement from the state to counties from $10,000 to $30,000 for habeas corpus procedures. In our research, this only affected 4 counties in the last couple of years. But the problem is we have a couple of rural counties that have several prisons, and one particular in Tatnall we have 4 prisons. I'll stand for any questions.
Yes. And I'll just add to what you've provided us information is these places where we have state correction institutions, there's filings of a habeas corpus by prisoners, either pro se or being represented. This then calls for the local courts, the local district attorney to incur the expense and time of those proceedings, and with such there is extra cost, not only the DA's cost, but also sometimes experts and other information they have to gather as a part of it, and that brings a cost. So they've been bumping up and going over what we've had previously allotted, and what we're doing here is looking to increase the amount from $10,000 to $30,000. There's only 4 counties that are affected by it.
Last year there was only 4 counties that even came close, and I think Titan was the only one that actually went over.
All right. Thank you. Any questions of the presenter by members of the committee? There being none, is there anyone else in the audience who wishes to address the committee on House Bill 319?
Mr. Chairman, I'll just say quickly, because I know everybody needs to get out of here. We fully support the bill. Deborah Nesbitt with ACCG.
I can certainly appreciate your support. All right. That being said, there anyone else? If there's not, we will close off further public comment. And House Bill 319 is now in the breast of the committee. Do we have, the chair will entertain motions.
Do pass.
Have due pass. Any discussion on the motion? There being no discussion, are there any amendments to be proposed? No amendments. The chair will call for the main question, which is a due pass to House Bill 319. All in favor signify by saying aye. Opposed, like sign. The motion carries. Thank you for coming and be with us today.
Thank you, sir. Thank you, committee.
And I think we're down to my bill, which I'll go ahead and call up. Mr. F. is not here yet. We have House Bill 434. This is on eminent domain. And I'll pull it up. Let me provide to, if I may, I'll let you chair the proceedings.
Okay, House Bill 434. Mr. Chairman, tell us about that.
Thank you so much. To give the committee and our audience a little background, back in 2006, there was a case that came out from the Supreme Court that I think was I'll say a landmark case, of course, but it also brought about change, I believe, in practically every state in the country. This dealt with eminent domain. And that case was the, I lost the name of it now. Kelo, thank you. Kelo versus the city of New London, which is out of Connecticut. And they were trying to, in the city of New London, trying to acquire some property for the purpose of having that land then transferred for redevelopment to a private party. And so the question that went up to the Supreme Court was this an appropriate exercise of the power of eminent domain? And you had a lot of interest in watching that, and some amicus briefs were filed for various public interest organizations. The Supreme Court came out and ruled in favor of the city of New London that yes, there was the authority under the federal constitution to have the right to acquire property by eminent domain and have that property then transferred to a third private party for redevelopment. And out of that decision, as I said, every state looked into their own laws of eminent domain, including Georgia, and made really some very substantial changes. We did, and I was involved back in 2006 as a part of the overview of that and the potential changing. I think one thing we did have happen, you were here, Mary Margaret, at the time, is, and well, you were there too, yes. You came and left and came back. But we had a balancing.
Like a bad virus.
we had a really an opportunity to do some really balancing of interest between the government and the private property owners, and out of that we made some major changes. So one of the changes we made, though, was to remove, as a cautionary matter, the ability of the local governments to acquire what we call blighted property, meaning property that is in such a deteriorated state that it is almost uninhabitable or unusable. It's really caused, what I consider to be a cancer in that community, because if the property is blighted, it's going to have an effect on the adjoining properties and others around that area, and eventually it's going to cause those properties also to become potentially blighted. So we took away the local government's right to acquire those types of property. And I think as we've had time go by, it's been recognized we may have overstepped the boundaries of what would be rational limitations on the use of the power of the eminent domain. With that said, this past few months, the local government associations, Georgia Municipal Association and Association of County Commissioners of Georgia, have worked together with the what I call the representative of the private property owners, which is the Realtors Group in Georgia, and they spoke to me about having come to a decision that we really do need to go back into the authorization of these governments to have a means to acquire blighted property with the thought in mind that it can be eventually or after acquisition sold to a third party for redevelopment, and the condition that is placed on that is the property shall remain in the same use classification for at least 5 years. So what we're saying is if the local government were to acquire the property and do so through condemnation and then have it transferred to a third party, two conditions go with it. One is it cannot be changed as far as the use. So if you're buying or having residential property condemned for a purpose, it has to stay with that same use classification for at least 5 years. And the reason for that is the purpose not to have somebody say, let's buy, gets this residential, then turn it into commercial overnight and expect it to be a substantial increase in value. The idea after 5 years, you're going to still have a need for the property to be rezoned. So the local government has some other means of controlling it past the 5-year time. If there's a desire to make some other type of development, they've got to come in and ask the city or the county for a rezoning of that property. We've also did another, I think, step that is important to recognize, and that is it's not just the local government saying we think this property is blighted and now start out in condemning it. If they feel they have property that's blighted, and we have standards in the law that describe what constitutes blighted property, the local government will first have to file an action in court with the Superior Court where that property is located, and the purpose of that filing will be to have the court make an inquiry by notifying all the property owners affected and people who have interest in that property affected to come to court and address the issue that the local government has raised, that the property is blighted and is to be acquired by that local government for redevelopment. So that is a first part of the process. It's a separate action. And you say we have statutory provisions that describe the steps, and it's in here as to what is considered blighted property. Find it back here. Well, let's see. I thought I had it in the bill, but it's actually in another section of the law. Where was that located, Jordan? I'm lost my thought on that part of it. Yeah, there's a provision that really describes in the law what is recognized as being blighted property. It is a different code section, my mistake. But anyway, the court will hold the hearing, and the purpose of that is if somebody feels strongly that their property is not blighted, they will have the opportunity to come in and address that at the court. The court will hear evidence and make the ultimate determination. If the court does determine that it's blighted, the party still has a right of appeal of that decision. So there's not cutting off their rights for ultimate review and due process all the way up to the Supreme Court of Georgia. Once it's determined to be blighted, then there will be a separate action to be filed by the condemning authority, local government, to acquire that property if they cannot negotiate a acquisition of it without condemnation. So the property owner is going to receive their true and full value of the property under those circumstances. As I say, we've had the last several years, I know in the city of Atlanta, and I believe we've got Mr. Burgess here from Savannah. There's been a strong need in some of these areas that have had older housing that's become deteriorated. The other thing you have happening so often with blighted property is a harbinger of crime, and used for drugs, used for other illicit and illegal activities. And so there's a need for the protection of those communities to try and stop that from continuing and growing. That, Mr. Chairman, is an overview of the bill. I'll be happy to answer questions from committee members.
Thank you, Mr. Chairman. Any questions from members of the committee? Mr. Dryer.
Thank you, Mr. Chairman. Chairman Willard, I can tell a lot of work has gone into this, and thank you for doing this. I've got, I guess, just a short preface and then one quick question. I'm representing two kind of distinct constituents in my district, and one is neighborhoods like Lakewood Heights in South Atlanta and East Point, which have massive amounts of blighted property, and school teachers and other people that I met while I was knocking on doors are pleading for help. At the same time, other neighborhoods in my district that are touched by the Beltline with literally billions of dollars of development happening are rapidly gentrifying. And it surprised me how quickly some of those neighborhoods have turned a corner on that. So I'm wondering about that 5-year period that property has to be maintained in its current use. What was your thinking behind that, Mr. Chairman?
Well, the thinking is to discourage a local government from working with a particular developer who would like to acquire some property that is currently, let's say, in a residential classification, and in doing so, use the right, and the only right that would be here is the right of having the property declared blighted as a way of transferring it to this third party. Why? Because there's already existing in the law a restriction that when a government acquires property through condemnation, the government has to keep that property for 20 years. So as a way of easing up that restriction, we put the 5 years there, saying if they're going to be redeveloping it and redevelop it for the purpose of residential use, they need to do that as a way of eventually, in 5 years, say there has been a change as you see around the Beltway. The decision can be made that's a more economic use of the property, more valuable use of property, then they could change that.
Was there any thought?
Question.
Yes, Mr. Chairman. And I guess the follow-on, was there any thought given to a longer time period than 5 years to prevent local governments from striking deals?
I think we'll let the ones who did that part of the negotiation. I took their information on that point as a let's say a benchmark, and recognize it and use that. Do any of the others want to speak on that? Come on up.
Sure. Good to see you, gentlemen. Have you ever been here before? If you would, just please introduce yourself. We're happy to have you, and please tell us about the bill.
Thank you. I'm Rushi Patel with the Georgia Municipal Association.
I'm Keith Hatcher with Georgia Realtors. And our business is based on private property rights. We consider ourselves to be the
Pull your
voice.
mic down so you can see.
We sort of consider ourselves to be the voice for private property rights. We were deeply involved in the reform in 2006, thanks to the chairman's efforts to curtail the abuses we saw in Connecticut. We think that was a very, very bad decision. The silver lining in that Supreme Court decision was that they can do that under Connecticut law, but it's up to each individual state to decide how they can use eminent domain. So we immediately came to General Assembly and said we don't want an environment where people can take one person's private property, turn it over to another based solely on additional tax revenue. And that's what was happening in New London, Connecticut. I'm sure you understand with your legal training, we view that as you no longer have property rights, you have a leasehold interest. Until such time the government decides that someone can generate more revenue, you have no rights. And we did not want to see that in Georgia. So we were actively engaged in the law to prevent that. And one element was to say that if you took property as blighted property, you could not do anything with that property for 20 years. And that was a very strong disincentive for any Walmart, and maybe I shouldn't pick on Walmart, but any big box store that came to town, which has happened across the country, and said, we want to take this neighborhood to build a commercial development. They're not going to wait 20 years to build that commercial development. So it was a disincentive for them to do that. What we've learned over time is it's also a huge disincentive for Mr. Patel and his organization to attack blight. Because if they're going to take parcels of property that are blighted and have to sit on them for 20 years, it doesn't make a lot of sense for them to have to do that. We recognize in hindsight now, we don't want to see a lot of micro parks. You know, they can use it for a public purpose, but they can't convert it. So we're in favor of putting those properties back into production. We think that's a smart decision to bring those properties back and eliminate the blight, which leads to crime and more blight. But rather than just eliminate the 20 years altogether, we said we'd like to see some additional protections. The Superior Court oversight that the chairman spoke to, we're very happy with that. I think that's a good additional protection for the property owner. And then the 5 years, we felt like there should be some period of time where you cannot convert it. Because again, the power of eminent domain is a very powerful tool. And what we didn't want to see happen is, let's say we're going to take 3 houses on this block by eminent domain, and then we're going to pressure the other 2 owners to sell us because we want to build a commercial spot. We recognize that land use does change over time. So we didn't want to lock it in for an extended period of time. We felt like 5 years was a good stopgap to sort of avoid the replacing of residential with commercial, because that's where we think we get into trouble. That's exactly what the Kelo case was based on. We took an entire neighborhood, bulldozed it under the premise that we're going to build commercial. As it turns out, that commercial never was built. The economy took a nosedive. All those homes were taken and that property bulldozed, and it sits vacant today. We did not want to see that happen in Georgia.
Mr. Chairman, can I ask a couple
Absolutely.
questions? Thank you. And I want to first thank both of you for taking the time to talk with me and even sitting down for a long period of time, I know, with some public interest groups as well, and explaining to them. And I know you got them on board with this, so thank you for that. But with the 20 years, that was for a public purpose. This lets cities take this and convert it to a private purpose sooner, but it just has to stay as a single family residence if that's the purpose for 5 years. Right. Was there any consideration of making that a longer time period, an 8 or a 10-year time period, so neighborhoods stay single family for a little bit longer?
Right. We discussed different time periods on that 5-year land use, and the reason we came to 5 years was we figured that is a good time period to disincentivize abuse of the system, but not harm private property rights of whoever purchases that property after the condemnation. We figured that was a good compromise.
Recognizing that things do change.
Right.
You know, to your point with the belt line, you know, none of that was done through blighted condemnation. That's all free market. So we didn't want to put ourselves in a position where these parcels can't keep up with the free market over time. So it's a balancing act. And I'm not saying 5 years is a magic number,
Right.
But I do think it represents a good safeguard, and it's much more reasonable than a 20-year hands-off policy.
And finally, I do like this bill. I think this is good work. I think this will help my communities a lot. But I may put forth an amendment to make that a little bit longer, because if we make it 8 years, then it just stays that it's converted to private use. It accomplishes the same thing, but it's preserved as a single-family neighborhood for 8 years, which generally is what I think people are looking for.
Other questions of members of the committee for our 2 witnesses? Anyone? Okay. Thank you all, gentlemen.
Thank you.
Appreciate it very much.
Did you have one, Miss Oliver?
To the Stockbridge florist.
They ended up in a settlement and were paid for their property. But it was, as you well know, you know, we were engaged, and that was a protracted, not a very pleasant situation. And it wasn't a Kelo case, but it was the closest we've seen in Georgia. And thanks to your good work in 2006, we don't anticipate having another problem like that in Georgia.
Okay. Any further questions from members of the committee? Okay. Thank you, gentlemen. We appreciate y'all coming up and working with us on this. Mr. Chairman, did you have anybody else that you wanted to call?
Not particularly.
Do we have
Sir,
anybody
if he's on
signed
the list
up?
here? Let's see. I think you had 434. You had the Lucy and
Okay. Ms. Nesbitt, you're signed up. Did you?
We support
You support it, okay?
And
All right.
Megan Middleton?
Megan Middleton? Is Megan Middleton here? Hey, Megan. Thank you. Thank you very much. Jim Burgess. Thank you, Mr. Mayor. Okay, that's all we had on the list. So we will bring the bill back to the committee. Any further discussion before we ask for a motion?
I'm gonna
Mr. Chairman?
get that, if I could quickly get that code section up that does describe the definition of blight. Is under our condemnation code, eminent domain 22-1-1, and it has blighted property, and the description of it's in here. It speaks as being presents two or more of the following conditions: as uninhabitable, unsafe, or abandoned structures, inadequate provisions for ventilation, light, air, or sanitation, and an imminent harm to life or other property caused by fire, flood, hurricane, tornado, earthquakes. We have natural disasters could affect the properties that cause them to become blighted. Fourth one is a site identified by the federal environmental protection agencies, or you have a Superfund property. That could also be a step measure to call it blighted. And then repeated illegal activity on the individual property. The maintenance of the property is below state, county, and municipal codes. So those are the type things that the court would look at in making its determination based upon the evidence brought before the court to whether or not it should declare the property blighted and bring about this process. That's all I have to say, Mr. Chairman.
All righty. Any other comments from the committee before we ask for a motion? Hearing none, is there a motion regarding the bill? There's a motion. Is there a second? There's a second. Any further discussion or amendments? Mr. Chairman? Mr. Dryer?
Thank you, Mr. Chairman. I do see neighborhoods turn over very quickly, and I think a few of the local governments that have asked me for this would feel a little whipsawed if 5 years from the date a blighted property is turned over, there's a commercial development. So I would just suggest maybe that time period would just be a little bit longer and still protect private property rights. So I would move to amend line 117 to delete the number 5 or the word 5 and replace it with the word 8.
There is a motion on the amendment. There's a second. Discussion?
I'd like to speak to that motion.
Mr. Chairman?
The thing that we look at, realize you're going to have someone who you're encouraging to acquire the property with the already restrictions like a covenant as to what they can do with it. The covenant being two things. It has to be used for residential and has to be used for that purpose for 5 years. My fear is, to my friend, that the longer you stress that out, the more it will probably dampen the incentive, we'll call it, of that person who's a private now developer who's being asked to buy the property to redevelop it. The thought being, we want the property used. Yes, we want it used in the same category, and yes, it should not be used for something else just as a way of, say, flipping the property. But we felt 5 years was a recognized time frame that that's from the time they acquire it now, not from the time it's condemned. So once it's acquired by the third party, they've got a 5-year time that they've got to use for that purpose and none other. I can't imagine somebody buying it and saying, I'm going to hold it in like inventory, not doing something with it because of the investment that I have to make over that time frame, and saying I've got an asset I can't change. And realize this, as I said earlier, realize this. They've got to go, if they're going to make a change, they've got to go back to the local government and get that change approved. So if the local government felt, well, you tried to trick us or something, they have no reason to say we'll allow the change from residential to, say, commercial or warehouse, where it may be, with that period of time having passed. So I speak against the amendment. I'd rather leave the bill as we have it. Thank you.
Any other comments, Judge Caldwell?
Thank you, Mr. Chairman. I'm going to speak against the amendment for a couple of reasons. Number one is the length of time it's taken to work on this bill with all the major players involved, and certainly with the city of Atlanta, the GMA, the ACCG, Association of County Commissioners, city of Savannah. And at the same time, this property would still be subject to zoning, which the city and or county, depending on which it is, can determine whether to change that zoning or not. And I certainly think that a 5-year is a good balance, because if you're going to change something, if you leave it for 5 years, you're either going to have built on it by that time, or you're going to be holding it for either a longer period of time. And so I would suggest that we leave it as is. That's what's been worked out by all the major players in this, over a long drawn-out process. And if we start then picking and choosing one part over another, we're going to possibly end up with something that's not workable and it's not usable for everybody. So I would just oppose the motion and say that we leave it just like it is.
Representative Holcomb? No? Was that?
Miss,
Oh, I'm sorry, Ms. Evans.
Thank you, Mr. Chairman. I have a question. Whether it's 5 or 8, whatever we put in the statute, would the local government still have the ability to grant a variance? I don't work in this area, so I don't know what the rules are. But no matter what time period we put, couldn't there be a variance?
I don't know what the variance, usually your variances deal with, and I'm speaking as my city attorney had, that deals with things that may arise, like setback requirements have to be changed. So you give them a variance as to how close they can be to a property line, or how big the garage may be, or have 2 garages or 1 garage. Usually things that are dealing with variances come about as a result of the topography sometimes of the property. Now, you can have, the building code. Now you can have what's called a use permit, but the use permit has to be, what's the word I'm looking for, compatible with the zoning on the property. So it's not changing the use of it. And you want something to say?
It's a covenant running with the land. So for that period of time, you cannot
Nothing.
change it through a variance.
Or in any other, maybe I don't want to get bogged down in the word variance. Is there a way to have an exception of any kind, whatever you call it?
Not as to use.
Okay.
Not
That's
as
the
to
question.
use.
Okay.
So that's what I'm saying. They're going to be, the property is used residential, however you want, or it could be, it could be a warehouse that's in such a deteriorated condition, this is danger and is considered blighted property. If they bring it down as a warehouse, it's still going to be under whatever zoning that warehouse was permitted. It's going to be in that same zoning classification.
Other questions from members of the committee? Any further discussion on the amendment? Hearing none, all those in favor of the amendment, please indicate by saying aye. Aye. All those opposed, same sign.
No.
Chair is in doubt. All those in favor of the amendment, please indicate by raising your hand. 1, 2, all 3. All those opposed, please raise your hand. Same sign. 1, 2, 3, 4. Amendment fails. Any further amendments to the bill? Hearing none, the chair will call. No further discussion. Hearing none, the chair will call the question on the bill. All those in favor of the motion do pass, please indicate by saying aye.
Aye.
Any opposed? Bill passes.
Thank you, sir. I will take back over and appreciate your support of the bill. And we'll have next hearing will be on, the next bill for hearing will be HB 221. Mr. Evstration. We're on House Bill 221 and working off of LC 411087. Yeah, good, right. So tell us about your bill, Ms. Evstration.
Thank you, Mr. Chairman. House Bill 221 and the revised committee substitute before you today is a product of over a year of work on this issue. It implements portions of the Uniform Power of Attorney Act as incorporated into Georgia law. Similar acts have been introduced and passed in 21 other states and the District of Columbia. The legislation really seeks to tackle several major issues that we have. First of all, in Georgia, the Power of Attorney statute is relatively undeveloped, as we've heard in testimony in previous hearings concerning this. Also, there are apparent contradictions and conflict. I'm sorry.
Have your mic on.
Oh, yes, sir. There's an apparent conflict in the existing form that's provided in statute, as well as some concerns about either acceptance of powers of attorney, whether or not they're being accepted when they should be, and circumstances in which these financial documents are being utilized as a means by which to effectuate a theft or a case of elder abuse. This legislation attempts to tackle all of those areas, and I had a chance to go over it in subcommittee yesterday, so maybe I'll begin by just summarizing here that Section 1 would remove the existing law. Section 2 would provide the framework by which these powers of attorney would be adopted and considered. And just to give you an overview, that would it includes the definitions, the limitations to the types of powers of attorney, the fact that it's durable by operation of law unless it otherwise states that existing powers of attorney are valid, jurisdiction, nominating a conservator similar to what we already have available in the advanced directives for healthcare, when it would become effective, when it would terminate, co-agents and the ability of those co-agents to act independently. Revised language, Mr. Chairman, as reported by the subcommittee, is appreciated by Representative Evans. The default of no reimbursement to the agent unless it's otherwise specified in the form. Acceptance, acting in the principal's best interest, which is an important component of the project here, that the agent must acts as a fiduciary and must act in the best interest of the principal, as codified with passage of this. Relief of liability as well as an acceptance of liability. That's 10-6B-15 and 10-6B-17. Petitions to the court, how an agent can resign, good faith acceptance or reliance upon the power of attorney, and consideration by financial institutions with a framework that allows financial institutions to act if there's a good faith belief that the power is not valid or the agent does not have the authority to perform the act requested, whether or not a certification, translation, or opinion of attorney has been requested or provided is a good faith exception for the financial institutions included. Article 2 goes through the actual authority of the agent. The following article, Article 3, is the model power of attorney form that is adopted from the Uniform Power of Attorney Act. It was incorporated into Georgia law with some additions from feedback I've received. And the final articles of the bill, sections of the bill, deal with specifically providing for law enforcement investigations that a power of attorney is not strictly, or use of a power of attorney to effectuate a crime is not a defense, or rather the elder abuse statute, I should say, is applicable, and that's under 16-5-105. The use of a power of attorney, this is under Part 3, the use of a power of attorney is provided for in Chapter 6B of Title 10 shall not in and of itself absolve a person from prosecution under this article. And this is so that law enforcement across Georgia can be educated and shown that these matters can be investigated and prosecuted, and that the fact that there was a power of attorney that was used does not in and of itself make this a strictly civil matter. I would be happy to stand for questions, would appreciate the committee's favorable consideration.
Thank you, sir. And this has been a 2-year process getting it worked through, and I think we've got a fine bill here personally, and I'm glad you brought it forward. Mr. Fleming.
Mr. Floor Leader, I'm trying to remember having discussed this bill before. Was it last year?
Yes, sir, it was last year, although I believe similar legislation was introduced Let me hold that. I'm not sure of that. But yes, sir, we definitely had a subcommittee, I believe it was your subcommittee last year, where this was considered.
I'm gonna try to blot bad things out of my memory. Maybe that's why I don't remember. So,
It's not bad now, right?
yeah. Well, what I was trying to remember is some questions that I thought popped up in that committee, and I was going to ask you about them being in this bill. I remember one thing that came up was was it a registry
Yes,
that we
sir.
were going to require of some sort? Is that in here?
No, sir, and
No?
that's
We had a discussion
intentional.
about that, yeah.
Yeah.
So the full committee met January 4th before this session began to consider the concept here.
Mm-hmm.
And it was discussed in committee. The
That's
policy
right,
position
yeah.
I've taken, Mr. Vice Chairman, is that registration could be an obstacle to effectuating powers of attorney or for principals to have it done efficiently. And so
It's
in
not,
order,
it's not in here.
no, sir. And but there is a notary and one witness requirement to, as well as contact information for the witness to help to avoid fraud, which I think registration would be.
So explain that part to me. That
Yes, sir. So to execute the power of attorney form, and by law, if this is adopted, it must be witnessed by a witness
mm-hmm.
who either observes the principal sign or direct that it be signed
Mm-hmm.
on his or her behalf, and that be observed by a notary and it be notarized.
The other thing I remember us talking about were, and this seems like last year, there was something about what documents one could notarize and your relationship to someone involved with preparing that document. And I remember us talking about, I think, and it could have been a prior bill and it may not be in here, there was some language at one point that seemed to say that your secretary couldn't notarize a document for you.
I think that was a different bill.
Think a different
that was
bill?
not
You don't-
something I
nothing like
carried,
that in
but
here?
but I know what you're talking about.
Yeah.
And that was not.
There's
included.
nothing like
That
that in
was a
here?
notary bill,
That's
Yeah.
a notary bill?
yeah.
Ah,
Welch's
okay.
notary bill.
Okay, all right. You're exactly right. Okay, thank you very much.
Thank you. I might say that registry thing was a thought I had, trying to say, well, for instance, the banks and third parties, how do they know this is truly the document or something? But it really doesn't make a change to it. You can still have a bad document recorded if you need to. But we did move us away from that idea. Ms. Oliver.
You probably mentioned this, but is this an optional form or a mandatory form?
It's an optional form.
Okay. So that means that all the powers of attorney that are out there now are not in any way invalidated by this?
That's correct. And that's specifically provided in this.
Thank you. Any other questions by members to the presenter? If not, we will ask for others. I think I know our director of the GBI, Vernon Keenan's with us today, and he's signed up to speak to the committee. We're so pleased to have you with us and grateful for all the things you and your department do in protecting the citizens of our state. And we'll let you tell us your thoughts about the bill.
Thank you, Mr. Chairman, members of the committee. The Georgia Bureau of Investigation very strongly supports this bill, starting with House Bill 78 a few years ago, which Chairman Willard authored. Georgia has enacted some of the toughest laws in the United States as it relates to the investigation and prosecution of crimes committed against the elderly and disabled adults. With those laws, we have trained thousands of Georgia law enforcement officers and dozens of prosecutors in how to investigate and prosecute these crimes. In fact, I pulled the data last week and found out that since House Bill 78 was enacted, there has been an increase of over 200% in the number of arrests made for crimes against the elderly and disabled adults. That is the value and the importance of what this body has done in enacting laws that can be used for tools. This is in the furtherance of what we need to be able to protect the elderly. What we find out is that many people believe that when they get that power of attorney, that they have absolute control over the assets of the grantee. Give you an example. I got a call from a local law enforcement officer down in South Georgia who was dealing with an incident where a lady in her 80s had signed a power of attorney over to her son. Her son had then sold her house and she was destitute. And his question to me was, what should I do? I said, go get a warrant and put him in jail. And his response is, but he has a power of attorney. This is an example of the confusion that is out there with law enforcement and prosecutors as it relates to power of attorney. It is not a license to steal, and this law will make it very clear, and we will use it to further train law enforcement and prosecutors on how to protect the elderly.
Excellent. And you've got a lot of stories. I know we had in subcommittee the ADA from Cobb County telling the horror story up there, the lady who's worth multi-millions of dollars, and over, what, $4 million stolen from,
Yes,
$4 million through a power of attorney stolen from her.
And that office was that they understood the law and stepped in and stopped the hemorrhaging. But many officers and prosecutors do not understand the law. This will clarify that,
So true.
please support it.
Thank you. Any questions of members of the committee of Mr. Keenan, Director Keenan? If not, we're thankful for your being here today to support the bill.
Thank you, sir.
We don't have anyone else signed up. If there's anyone else, I know we got some lovely ladies here with us today that have been involved with this. Would you like to stand and just be recognized or say anything to the committee?
Allie Michael, here on behalf of AARP of Georgia, and we very much support the sector. Sheila Humberstone with the Alzheimer's Association Georgia chapter, just thrilled with all the work that's been done by all the partners in the room and appreciate your favorable support.
Thank you. Others?
Vicki Johnson, Chair of the Georgia Council on Aging. We support this bill.
All right. We appreciate you being with us today, and thank you for standing to be recognized. If there's no one else to speak on the bill, the chair will close off further public comment. The bill is now in the breast of the committee. Do we have a motion on the bill? Move to pass and second on House Bill 221. Do we have any discussion on the motion? There being no discussion, are there any amendments to be proposed to the bill? There are no amendments to be offered. The chair will call the main question, which is a do pass House Bill 221 as LC 411087 ERS. All in favor of that motion signify by saying aye. Aye. Opposed, like sign. Motion carries. We're grateful.
Mr. Chairman.
Pardon me? By sub, it is by sub from the committee, yeah, substitute. Do pass by substitute. And I believe that concludes the bills we have today. I will remind those on the committee there is a dinner this evening we've been invited to, so hope everybody can join that great opportunity. It's a wonderful restaurant. It'll be on the left side going up. You know where the well, it's a great city. You come visit. I tell you, you get off Roswell Road, head north, get your GPS working. It's on the left side where the what's the theater? I'm trying to remember the name. That same about a quarter mile up, very close. Sun Trust. All right, yeah.